Good afternoon. It is now a little past 12 o'clock, and it is time to continue with the second to last panel of this wonderful conference. I will be chairing this panel. My name is Joachim Savelsberg from the University of Minnesota. We have three presenters who are here in person. We also have a written presentation, and I was asked to point this out. The writer of the final paper is Hannes Püschel. The paper is entitled Coming to Terms with the Past Through Penal Law, ? Denial of Historical Atrocities and the Public Use of Soviet Symbols in Central and Eastern European Penal Law. This paper is laid out in the back of the room, so if you're interested, please feel free to go to the back row, or maybe Hannah, will you pass it around? Thank you very much. All right, so we should move to the panelists who are in fact here in person.
He's actually here. He's actually here.
Oh, he is here. Oh, I apologize I did not mean to deny your presence, but I'm glad you are here, and so if there are questions, maybe you can participate and contribute in the conversation afterwards. Thank you. Thanks for pointing out. So we will proceed in the order in which presenters and papers are listed in the program. And the first presenter is Aleksandra Gliszczyńska-Grabias, and her paper is entitled Communism equals or versus Nazism, Central and Eastern European Unwholesome Legacy at is it the European Court of Human Rights? Of
right.
course, thank you. There's a wonderful biographical blurb that I have, and you have an impressive career. You earned you graduate from the European Studies Department, Faculty of Law in Poznan, and you're currently a senior researcher at the Poznan Human Rights Center at the Institute for Legal Studies there and at the Polish Academy of Science. So these are wonderful places you are affiliated with and have been affiliated with, and we are very eager to listen to your talk. Thank you very much.
Thank you very much. And thanks to organizers for having a chance to present my paper today. In 2010, Timothy Snyder, a distinguished professor of history at Yale University, published the book Bloodlands, Europe Between Hitler and Stalin, in which he tells a story of Nazi and Soviet mass killings on lands between Berlin and Moscow. And the book was particularly, it received a number of awards and was particularly warmly received in the states of the former Eastern Bloc, including in Poland, mainly for one reason. Snyder decided to reveal the magnitude of Stalinist crimes and made them, in a way, equal with the crimes of the Nazis. And he presented Stalinist crimes from the perspective of their victims, entire states and nations, and introduced a narrative which was very often unknown to foreign, mainly American readers. And in this way, he exposed himself to strong criticism of those who do not permit such equivalent treatment of both regimes and demand that reference to Nazis' crimes, first and foremost of the Holocaust, be different and somewhat privileged. And disputes over this controversy appeared also in the political and legal sphere. They were manifested, for example, in the European Parliament, which in April 2009 adopted a resolution establishing the European Day of Remembrance of Victims of Stalinism and Nazism. And during the discussion in the European Parliament, at that time President Hans-Gert Pöttering brought up the classic study of Hannah Arendt on totalitarianism, concluding that both totalitarian systems, Stalinism and Nazism, are comparable and terrible. But opposition was also voiced, and one of the representatives of the Party of European Socialists stated that, and I quote, While I'm in favor of the maximum objectivity in analyzing Europe's history, and while I recognize the horrific nature of the crimes of Stalinist Russia, I'm afraid that this resolution has elements of historical revisionism. This political relativism threatens to dilute the unique nature of the Nazi crimes, and in doing so, provides an intellectual underpinning of the ideologies of today's neo-Nazis and fascists. And the resolution gained important yet only symbolic significance, and that's why many states which were perceived as victims of Stalinist and communist repressions made an attempt to introduce legally binding solutions. However, the European Commission has rebuffed the call for the EU to legislate against the condoning or denial explicitly of Stalinist and communist crimes. But of course, states have a discretion to formulate the national legislation in this regard in the way they wish to. So, for example, the Polish legislator equated in the scope of penalization of public dissemination of Holocaust denial and Katyn denial. So in Poland, this is equally forbidden to deny the Holocaust and to deny the Katyn massacre. And after the fall of the communism, as Central and East European state acceded to the European Convention of Human Rights and the whole system of European protection of human rights, a complex and difficult historical legacy of this part of the continent yielded an important challenge to the European Court of Human Rights. And yet the Strasbourg standards developed in cases relating to the Nazi regime in the context of freedom of speech, freedom of assembly, association, and election rights, which I will concentrate on, have not been automatically extrapolated by the European Court onto its jurisprudence concerning the communist regime. And in my paper today, I will be, first of all, interested in finding out whether the same judgments or very similar judgments would be given in Strasbourg if and when the case was not about events concerning and connected with Stalinism and or communism, but with Nazism. And for that, I have chosen three cases which I would like to discuss now. The first one concerns, and I call it like Red Star versus swastika. In July 2008, the European Court issued a landmark judgment in the case of, I'm sorry to all Hungarians for the pronunciation, of Vajnai versus Hungary. So the Hungarian national vice president of the Workers' Party complained that his freedom of speech was violated when in 2004 he was convicted of the offense of using a totalitarian symbol by wearing a 5-pointed red star on his jacket during the public assembly. The Hungarian authorities claimed that they had to counteract the dangers associated with the totalitarian communist regime. And controversially, the European Court found that the applicant's right to free speech was violated, and that almost 20 years after the fall of communism in Hungary, the authorities' actions were neither necessary nor permissible in a democratic society. In a crucially important element of this judgment, the court refers to the danger involved in the translation of the social feelings and fears and opinions into legal regulations. The court said, "The court is of course aware that the systematic terror applied to consolidate communist rule in several countries, including Hungary, remains a serious scar in the mind and heart of Europe. It nevertheless considers that such sentiments, however understandable, cannot alone set the limits of freedom of expression. Such emotions cannot be regarded as rational fears." So, in other words, the Strasbourg court defined which fears grounded in the recent history cannot be regarded as rational and therefore undeserving of legal protection. And what arguments have been raised to support such conclusions and stating such a hierarchy of fears, as I would call it? First of all, the court said that the measures applied by the authorities against the applicant were not necessary in a democratic state and society, as there existed no real danger of the communist regime being restored in Hungary. In the opinion of the court, the ban on displaying symbols such as the red star in public, when such displays are unaccompanied by the dissemination of propaganda in support of a totalitarian system, is too severe and for that reason unacceptable. In its judgment, the court strongly emphasized that the applicant did not express any totalitarian views or contempt for the victims of totalitarian regimes. And the facts of the case actually prove the validity of the arguments about the lack of any danger of communist regime being restored in Hungary, and that there was no dissemination of totalitarian propaganda by the applicant. At the same time, considering European courts' case law on broadly understood activities inspired by National Socialism, unlike in the communist ideology, the Strasbourg court does not apply a test to prove whether there actually was a real risk of the restoration of the criminal regime based on this ideology, or whether there was any public promotion of the totalitarian regime. Thus, it is difficult to imagine that a similar judgment, as in this Hungarian case, would be rendered in a hypothetical case concerning the public display of the swastika symbol on the jacket of a member of the far-right National Democratic Party speaking during public assembly in Berlin. Case number 2, neo-communists as political force. Under the decision of Romanian courts, the Party of Communists, PCN, an organization established in 1996 with the statutory aim of protecting workers' rights and sustaining the principles of the communist doctrine, could not be registered because of the fact that it would aspire to overthrow the government and democracy and in this way re-establish the communist system. The complaint brought before the Strasbourg judges concerned the allegation that the refusal to register the party as a political party had infringed their right to freedom of association as guaranteed by Article 11 of the European Convention. The court analyzed the documents which the national courts used as the basis to refuse the registration. Finding that Article 11 was violated, the court emphasized that, and I quote, these documents did not contain any passages that might be considered a call for the use of violence, an uprising, or any other form of rejection of democratic principles, which was an essential factor to be taken into consideration, or for the dictatorship of the proletariat. Thus, the court stated that the mere reference, either through the name or program of the organization, to the heritage of the communism could not be synonymous with the rejection of the principles of democracy, although communism, which prevailed in Romania for a few decades, rejected and contradicted democratic rules to their core. Again, it is difficult to assume that the same conclusion could be formulated in Strasbourg in a similar case, which would be instituted against Germany or Austria, even though no doubts as to the completion of transitional period of coming to democracy after the Second World War there can be raised. So far, this historical context, the two countries blemished with Nazism, helped the court to accept even far-reaching restrictions of individual rights and freedoms by national authorities. The rulings concerning Austria and its prohibition acts in German Verbotsgesetz, under which any action based on the idea of National Socialism were sometimes severely penalized, can serve as an example here. Although this concept of action based on the idea of National Socialism was not clear and not sufficiently specified, the Strasbourg court accepted that the Austrian legislator had a legitimate right to include in this definition all actions of this kind. And here, as noted by Harvey in the context of Strasbourg judgments concerning far right, the court, and I quote, has been much more ambivalent in its attitude to anti-democratic actors coming from the other end of political spectrum. And lastly, a case concerning election rights and communist past. Again, I'm sorry for the pronunciation, which is definitely wrong. The case of Danika versus Latvia. And this is perhaps the most interesting and most controversial of all cases discussed here. The facts of the case were as follows. Mrs. Danika, a Latvian politician, was disqualified from standing for election on account of her former membership in a Communist Party of Latvia, CPL, which during the Soviet period was a regional branch of the Communist Party of the Soviet Union. And after Latvia has regained its independence on 23rd of August 1991, the CPL was declared unconstitutional with a stipulation that persons who had participated in the activities of CPL would be not allowed to stand for political office. Thus, the complaint concerned the alleged violation of the right to stand for election, which resulted from the applicant's disqualification. And the ruling of the chamber recognized the violation of the applicant's rights. Conversely, the Grand Chamber of the court admitted the arguments of the state. It has decided that with incorporation of such restrictions, Latvia tried to protect its young democracy against persons who had actively opposed it when the state was leaving the yoke of the former Union of the Soviet Socialist Republics. And thus, the Latvian state was found to be better equipped with tools to assess the risk that the permission to stand for elections given to persons such as the applicant would entail. The judgment, there were many dissenting opinions included into the judgment. And in those dissenting opinions, individual judges opposed the conclusion of the court, arguing that the rights of the applicants were violated. They based their arguments mainly on the belief that even if similar restrictions had to be imposed during the difficult times of transformation, they are no longer necessary at the time when Latvia became a member of the family of democratic states. Again, it is worth noting that a similar argument has not been used in the 1979 Strasbourg decision on the inadmissibility of the complaint about perpetual deprivation of the right to vote of the person who had been convicted for collaboration with the Nazi occupant. Although the ban was still in force over 30 years after the end of the Second World War, when Belgium, so the state against which the complaint was lodged, was a stable, strong Western democracy, it was decided that, and I quote, "The purpose of legislation depriving persons convicted of treason of certain political rights, and more specifically the right to vote, was to ensure that persons who had seriously abused in wartime their right to participate in the public life of their country are prevented in future from abusing their political rights in a manner prejudicial to the security of the state or the foundation of a democratic society." And some concluding remarks. The judgments of the Strasbourg court, regardless of their intellectual and juridical value, which is often significant, shape constitutional and legal discourse in Europe more than any other factor, and influence the way in which European lawyers and subsequently European societies think about the proper instruments of and limits to legal coping with the past in the collective memories. And there is no escaping of the conclusion about the difference in its treatment of the Nazi and of the communist past. One of the most significant examples concerns the recognition of Holocaust as a clearly established historical fact that cannot be denied, and the varying attitude to taking the same position towards the unlawfulness of the Molotov-Ribbentrop Pact and the unlawful character of the annexation of Baltic states by the Soviets. I do not necessarily wish to deplore and condemn such double standards, because some of the differences belong to a category of relevant distinctions based, for instance, on a rational application of tests such as the capacity of a given expression to promote hatred, violence, etc. These are very contextual judgments, and those contextual differences may account for a different treatment of those two types of troubled legacy, so communist and Nazism. But when all is said and done, the deep differences in approach remain, and no matter how much we take account of the context-sensitive differences, there is no denying that in scrutinizing the measures of the so-called militant democracy in the Councils of Europe member states, the European Court is more lenient towards restrictive regulations addressed against Nazi speech or association than towards their communist counterparts. And this is emblematic and rather fundamental difference in the treatments, and also it should be, in my opinion, seen as troubling. With all certainty, the crimes of Nazism are an element of historical narration and identity of Western Europe which created the European system of human rights protections. The crimes of Stalinism and communism remain to a large extent beyond this circle of remembrance and identity which sets out the framework for the sense of community also. Names such as Katyn will never penetrate the Western consciousness to the same degree as, for example, the Crystal Night. In a 2007 survey of students aged 15 to 20, the Institute for Information on the Crimes of Communism in Sweden found that 90% had never heard of the word Gulag, while the same number were well informed about the Auschwitz. In addition, 40% believed that communism had contributed to increased prosperity in the world. Therefore, the feeling of bitterness and injustice which can be felt towards after some of the decisions of Strasbourg, particularly by those for whom the symbols of the Red Star or hammer and sickle mean only crime, persecution, torture, deprivation of one's dignity, or loss of family members, is to a large extent understandable. Thank you.